So today I want to give you an overview of the Texas Constitution and just a very bitty bit about the structure of it and ways in which it's unique, different from the United States Constitution, which you're more familiar with. And last time permitting, I want to go into one or two really unique aspects of it and the history of those and how they kind of developed. So the Constitution, the Texas Constitution that we have now is the seventh one that was written for the state of Texas by my count. And this was written in 1875 in a constitutional convention. These were the delegates to that constitutional convention. And it took effect on February the 15th, 1876. So it's fairly old now, not as old as the U.S. Constitution, obviously, but fairly old. And it's been fairly stable. It's been amended many times, which I'll get to in a minute, but it is still basically in effect. Now, it reflects a couple of ideas that were really strong, really prevalent in the minds of the people who wrote it at the time. One is a distrust in government institutions, and you'll see that in some specific provisions that I'll get to later. And so there was an emphasis on the freedom and the liberty of the citizens, and for that, to these founders, that meant less government, or very limited government, so that would increase the scope of freedom for the citizens. Another interesting point, which I'll get to later in a lecture on the politics of Texas, this Constitution was written entirely by Democrats, and it instituted or it began a period of about 100 years of almost uninterrupted Democratic Party rule in Texas until the 1970s is when, at the state level, Republicans finally began to really change the Democratic Party dominance. So the structure of the Constitution, it has 17 articles plus a preamble and an appendix. The first thing you'll notice about it, it is really long. I've never read the whole thing. I'm sure somebody somewhere has, but most people haven't. It is 86,000, last time I checked, and these numbers might be a little off because they're constantly changing. Last time I checked, there were 86,936 words, making this the second longest state constitution in the United States. The average state constitution is 38,548 words. The Texas Constitution, one of the reasons it's much longer than other constitutions, it has been amended many times. It has been amended 517 times, whereas the average state constitution has only been amended 152 times. So it's over twice as long as the average of the other 50 states, and it's been amended over, 3 times as much, almost 4 times as much. To compare this to the United States Constitution, which you can sit down and read in half an hour, the U.S. Constitution has 4,543 words in the original document, so about 1/20th the Texas Constitution. The U.S. Constitution has only been amended 27 times, so about once a decade, or slightly less, in the history of the United States. Whereas the Texas Constitution, it's amended every couple of years. So that's why it's constantly growing and expanding, becoming longer relative to other states. Why is it so long? The first obvious answer is that it's relatively easy to amend. So like I said, every couple of years we add to it. In Texas, in order to amend the Constitution, you need 2/3 of both houses of the legislature, so 2/3 of the House, 2/3 of the Senate, and then a simple majority of voters. Right? Whereas in the United States Constitution, to amend it, you have to have 2/3 of the House and 2/3 of the Senate, but then 3/4 of the states. And that step is very, very hard to get past. And so that means that the Texas Constitution is much easier to amend than the United States Constitution. And that was by design. They made it, to be that way. Another closely related reason, the Texas Constitution restricts the power of government to specific enumerations. In other words, the government can only do the things that it is very specifically granted the power to do in the Texas Constitution. The U.S. Constitution has a necessary and proper clause. It's called the elastic clause. It expands the powers of the federal government beyond those powers that are specifically enumerated in the document. In other words, the U.S. government has powers that are implied, not written down, but understood, to sort of emanate from those powers that are specifically granted. In Texas, if the government wants to do something new or do something that isn't specifically authorized to do in the Constitution, they have to go back to the voters and get a majority of the voters to approve. So they're constantly, every couple of years, going back to the voters and saying, can we do this now, basically? And that's why the document just grows and grows and grows. So let me talk about the articles a little bit. Let's go through the different sections of the Constitution and what they do. Article 1 is interesting because right off the bat you can see a difference between the Texas and the United States Constitutions. Article 1 is the Bill of Rights for Texas. In the United States Constitution, the Bill of Rights comes at the end in the form of amendments. So we call the first 10 amendments the Bill of Rights. Here, we have them all in Article 1, and we periodically add to them, right? Every couple of years when we have constitutional amendments, one of those amendments might get added to Article 1's Bill of Rights. In fact, it just happened last year. So the Bill of Rights contains 34 or 35 sections. I think it's 35 now. And it contains most of the protections found in the U.S. Bill of Rights. For example, freedom of speech, freedom of religion, protection for the rights of people who are accused of committing crimes. These are all basically identical in Texas and the United States Bills of Rights. There are some interesting differences, though, things in the Texas Constitution that are not in the U.S. Bill of Rights. I'm going to talk about this at more length a few slides down, but there's an Equal Rights Amendment, which guarantees equality based on sex, race, color, creed, and national origin. That was written into our Bill of Rights. Another interesting change or difference, in Texas, the writ of habeas corpus may not be suspended. In the U.S. Constitution, it may be suspended by Congress in times of war or national emergency. In Texas, it says it cannot be suspended, period. Now, you probably don't know or remember what the writ of habeas corpus is. It's an ancient legal doctrine, which the Latin means something like habeas corpus, you have the body, or something like that. And what the doctrine was a protection against arbitrary imprisonment. If someone was arrested and thrown in jail by a sheriff or by the king, he or she could apply to a judge for a writ of habeas corpus. It would be a letter that the judge would send to the jailer and say, show me the body. Meaning, show me the person that you're holding, right, that you are incarcerating, and tell me why he's in jail. Give me a reason. Give me a justification, right? Tell me what he's accused of, what crime. And this is a protection against arbitrary imprisonment, because now they have to tell the judge why they're holding you, right? They have to give a reason for it. They have to say what you're accused of doing, what the evidence is against you, etc. You can't just be held forever in a jail cell with no explanation given. In the United States, that can be suspended. It has been suspended, most notably during the Civil War, when in the Union, over 1,000 people were arrested and put in military jails and not charged with a crime, not given a trial, not given a chance to exonerate themselves. They were just put in jail. They were considered to be potential traitors or potential saboteurs or something. And so the writ of habeas corpus was suspended, meaning they had no right to a jury. They had no right to a judge to review why they were being held. But in Texas, it says that can't happen, period. The governor can't suspend it. The legislature can't suspend it. Anytime you're arrested in Texas, it has to be according to the rule of law. They have to charge you with a crime and give you an opportunity to defend yourself. Okay, another interesting aspect of the Texas Bill of Rights, it has a lengthy section with protections or rights of victims of crimes. Another interesting section is from 2009 or so, an amendment that says private property cannot be taken by the government for the purpose of transfer to a private entity for the primary purpose of economic development or enhancement of tax revenues. This is talking about the idea of eminent domain. And there is in the Fifth Amendment to the United States Constitution a rule that says that the government cannot take your property without just compensation. They have to pay you the fair value of the property, but they can take it. And commonly, for hundreds of years, it's been understood that they can take it for a public purpose, to build a road, to build a highway, to build a subway, whatever, to make a federal court building. Those are all legitimate purposes, but they have to compensate you for it. Well, there was a huge controversy about 15 years ago. A city government, a local government, I think in Connecticut, wanted to take some people's houses, raise the houses using eminent domain, but then give the land to a private corporation that was going to build something there. I don't remember what. Office buildings or something. And the government thought, we're going to get more tax revenue from the corporation, so this is in our best interest. The people said, you can't use eminent domain unless it's for a public purpose. You can't just use it to take a house away from someone you don't like because they're poor, to give it to someone you do like because they're going to be richer and pay more in taxes. Well, the government in Connecticut won. The people lost their homes. They took the money, the homes, and used eminent domain to give it to somebody else. Texas was one of several states that was outraged by that decision. And so we wrote into our Constitution, you cannot take the private property to transfer it to a private entity for the primary purpose of economic development or enhancement of tax revenues. So that was meant to protect people in Texas from that sort of thing happening here. Another interesting part of our Bill of Rights, it's still there, but it's no longer effective. Section 32 was added in 2005, and it declared marriage as a union between a man and a woman. And that is no longer operative because there was a 2015 Supreme Court decision that struck down laws and constitutions to this effect all across the United States. Article 2 is also a little bit different from the United States Constitution. The United States Constitution has the same theories for the powers of government that this has, but Texas makes them explicit. So it explicitly discusses separation of powers and checks and balances, and says no person or collection of persons being of one of these departments shall exercise any power properly attached to each of the others, except in the instances herein expressly permitted. In other words, it explicitly says if you're in the executive branch, you don't have legislative powers. If you're in the legislative branch, you don't have executive powers, and vice versa. Here are the three branches of government. You've probably seen them many times in civics classes. It's the legislative, the executive, and the judicial, with the basic idea that the legislative branch makes the laws, the executive enforces them, and the judicial interprets the laws and runs the courts. And we're supposed to have, and each of these branches has, in addition to its own functions, ways that it can check the power of the other branches. So the executive branch has its own functions. It can appoint executive officials, executive members like the governor, the lieutenant governor, can serve on boards. They can submit budget proposals to the legislature. Perhaps most importantly, they are tasked with enforcing state law and court orders. They also have checks on the legislative and judicial branches. The governor can call special sessions, force the legislature to come and work on a problem. He can dictate the special session agenda. He can tell them, you're here to work on a voting rights bill, or you're here to work on an equal rights bill. The governor has veto and line item veto power, so he can veto legislative acts or parts of those acts in some cases. He has a check on the judiciary. The governor can appoint judges in cases of vacancies. This is not nearly as powerful as the president. The president has more power over the judiciary than the Texas governor does. The legislative branch obviously proposes and passes laws. It has the power to tax and to set the budget. It also has checks on the executive and judicial branches. For the executive, the legislature has oversight of state agencies and departments. They can hold hearings. They can call in executive branch members to testify at those hearings, and that way they can oversee what's going on. And they have the power to impeach executive branch officials or judges. And it's rare, but it has happened that they have impeached judges and executive branch officials. They have the power to propose constitutional amendments, which is also a big power. The judicial branch, of course, their primary functions are to interpret the law, to settle disputes and matters of criminal and civil law. They have the power to review executive orders, administrative regulations, and executive implementations of law, and decide if the executive is adhering to the Constitution, the Texas Constitution and the United States Constitution. It can enforce both against executive orders or regulations. Also, the judicial checks the legislature the same way. In Texas, just like in the United States judicial branch, the judges can review legislation to see whether or not it's constitutional. So the legislative branch, this is the view of the Texas House of Representatives. The legislative branch is divided into two branches, two houses, a Senate, which has 31 members, and a House, which has 150 members. The legislature meets once every 2 years for 140 days, but they can also be convened by the governor for special sessions, where the governor will state specifically the purpose for which the legislature is convened. And they are paid only $600 per month. So I mentioned earlier that way back in 1876, the people who wrote this Constitution were distrustful of government. Here you see one example of how that is written into our Constitution. They only allowed the legislature to meet once every 2 years because they didn't trust the legislature, so they didn't want to give them time to pass laws. They figured the more time they're in Austin passing laws, the more mischief they will cause, so we will only allow them to meet once every 2 years. They only get paid $600 per month, because they didn't want anybody to be able to live off of the salary of a legislator. They didn't want professional lawmakers. They wanted ordinary people with other jobs to do this basically as a side issue. The executive department, or the executive branch, is somewhat unique in Texas. In the United States, you have a unitary executive where the president is the one final authority over the entire executive branch. But here we have a plural executive where we have different executives who are all, they have divided power, right? So they have distinct different jobs, and they're elected separately by the people. So the governor, the lieutenant governor, the controller of public accounts, the commissioner of the general land office, and the attorney general are all elected by the people of Texas separately, so they don't have to answer to each other. The lieutenant governor doesn't have to answer to the governor. The governor didn't pick the lieutenant governor. They don't even have to get along with each other. They don't even have to like each other. And Texas specifically divided power that way to try to keep our governor, our lieutenant governor, from becoming as powerful as a president can or a governor can in a different system. The governor's term is 4 years with no limits. This is a new-ish change. It happened about 50 years ago. Back when the Constitution was written in 1875, it was only 2 years. And the reason was they didn't trust governors. They wanted it to be a short term so you could get rid of them quickly if they were corrupt or abusive or tyrannical or whatever. So this is the plural executive system I was talking about. It's just a different chart with the same information. The voters elect each of these people independently. The lieutenant governor, the commissioner of agriculture, the attorney general, governor, commissioner of general land office, controller of public accounts, state board of education, and members of the Texas Railroad Commission. So the executive power is divided among those different elected officials. Article 5 discusses the judicial branch, and what's interesting about this is that Texas has 2 high courts. In the United States, we have a Supreme Court, which is the ultimate arbiter of disputes. In Texas, we have 2, what you might call Supreme Courts. We have the Texas Supreme Court with 8 judges and 1 Chief Justice, 9 in total. And it decides, it is the ultimate arbiter, the ultimate decision maker on all civil cases, right? Cases that aren't crimes. In the Court of Criminal Appeals, this is the high court for criminal cases. The Texas legislature has the right to create additional courts and has done so, as you can see on this chart, creating district courts, county level courts, courts of appeals, and so forth. A little bit about the requirements for judges on the Supreme Courts. They must be 35 years or older, licensed to practice law in Texas, a citizen of the United States and of Texas. They must be practicing lawyers or have been a lawyer or judge of a court of record for at least 10 years in Texas. Now, not all judges that you see on this chart must be lawyers. County judges, they're actually not listed there, but no, the Constitutional County Court, that's a county judge. County judges and justices of the peace don't have to be lawyers. Article 6 describes suffrage in Texas. Suffrage means voting, the right to vote. To vote in Texas, you must be a citizen of the United States and a resident of the state of Texas. There are three main groups of people that are denied the right to vote in Texas: those under the age of 18, those convicted of felonies, and those who have been declared mentally incompetent. And of course, non-citizens. I could have said a fourth group. Another group of people that aren't supposed to vote in Texas, but somehow, sometimes, let me rephrase that. Technically, you're supposed to be alive to vote. But in one famous election in Texas history, lots of dead people managed to vote and change the outcome of the election. This is a picture of Lyndon Johnson. He was the president of the United States in the 1960s. And he really launched his political career in the 1930s and 40s. He became a representative in the House of Representatives from Texas. And then in 1948, he ran for senator. He was in a three-way primary. He was a Democrat, and so he was in the Democratic Party's primary. And he trailed former Governor Coke Stevenson by over 70,000 votes. But he came in second place, so there was a runoff between Johnson and Coke Stevenson. On the election day for the runoff, LBJ's opponent, Coke Stevenson, led by under 150 votes out of the 1 million votes that had been cast. So it looked like at the end of election day, Stevenson won super close, less than 150 votes difference. 5 days later, Jim Wells County in South Texas amended its return. They said 202 additional ballots had been found, hidden in box number 13 from the town of Alice, Texas. 200 of the 202 people had voted for Lyndon Johnson. By a miraculous coincidence, each had signed their names in alphabetical order, in the same penmanship, each apparently using the same pen, and their names were all identical to the names of people from the local cemetery. So with those votes discovered in the box, he won by 87 votes, and he was nicknamed Landslide Lyndon afterwards. Probably one of the most famous anecdotes or incidents of election corruption in Texas. Article 7 talks about education. Section 1 says, it shall be the duty of the legislature of the state to establish and make suitable provision for the support and maintenance of an efficient system of public free schools. Section 10 mandates the establishment of a university of the first class, the University of Texas. Section 13 requires the establishment of an agricultural and mechanical department, and that's Texas A&M University. So those two school systems were created in the Constitution. Articles 8 through 16, I won't get into. They cover these topics: taxation and revenue, counties, railroads, municipal corporations, private corporations, Spanish and Mexican land titles, public lands and the land office, the rules for impeachment, and some general provisions in Article 16. Article 17 discusses amending the Texas Constitution, and I've already briefly mentioned this. So the method is, you have a proposal by 2/3 of the vote of the full membership of the House, that's the House and the Senate, and then if it passes by 2/3 vote in the House and it passes by 2/3 vote in the Senate, it goes to the voters. There's a special election, a constitutional election, and the voters, a majority of the voters must approve of the proposal. Since 1876, the legislature has proposed 700 amendments, and 517 have been approved. Voter turnout for these elections is usually very low. In odd year elections, the voter turnout is usually less than 10% of the voting age population, And what that means is only those people who are most affected by an amendment are likely to turn out to vote for or against it. So a tiny fraction of the Texas voters who are highly motivated on a certain issue are almost the only ones who bother to vote at all. There's another way called the Constitutional Commission that has been used to propose changes to the Constitution. The last time this was done was in 1973. The legislature created a Constitutional Commission or convention, but the 1974 convention failed to adopt any of the commission's proposals. In 1998, a Republican, Bill Ratcliffe, and a Democrat, Rob Junell, proposed a new constitution, which was drafted with the help of students from Angelo State University, but it died in committee. So none of the proposals even made it to a full vote in the House or the Senate. Texas allows the legislature to place on the ballot an amendment calling for a constitutional convention, and that's the 1974 convention I mentioned there. This was last done when the legislature met in 1974 for 150 days, but they failed by 3 votes to propose a new constitution. 8 of their recommendations were then sent to voters individually, but the voters rejected all 8 of the recommendations. So now I want to talk for just a few minutes about one of the more interesting amendments to the Texas Constitution that has happened. And that is the amendment to add a Texas Equal Rights amendment to our Bill of Rights. And this is the public notice for the constitutional amendment. You can see the language of the amendment is at the bottom right. It says, "This is the constitutional amendment to provide that equality under the law shall not be denied or abridged because of sex, race, color, creed, or national origin." And this was meant to redress significant inequalities in Texas law, especially inequalities that affected married women. So a single woman from the 1800s up until then had a lot of the basic liberties that you take for granted. Single women could vote, they could not vote or serve on juries in the 1800s, but they could make contracts, they could sue or be sued, they could choose where to live, to own or control property. If they were widowed, they had custody of their children. And there were some rights that women in Texas had that they inherited from Spanish law. So in some ways, Texas was more advanced than other states that inherited the English common law. So women could own, in Texas, they could own separate property, the personal effects, real estate, and stocks and bonds possessed at the time of marriage. And they could share equally with their husbands the wealth that was amassed during marriage. And a married woman had the right, according to the Spanish law that was inherited by Texas, to leave her separate property in her will and her share of the community property to whomever she chose. Nevertheless, Texas statutes and court rulings gave husbands the management of their wives' separate and community property. The law allowed them to bring suits to protect or enforce their wives' separate interests, as well as those of the common property, and her earnings from her separate property were community property. They belonged to both of them, and they were under his control. Until 1967, Texas law put a wife's salary, bonuses, and wages under her husband's control, to the extent that technically only he could contract her services to another person. As a general rule, then, the husband served as the family's financial and economic agent. A simple way of thinking about that is from the 1800s all the way until the mid 1900s, a married woman was legally like a child, governed by her husband. Right? She couldn't sign contracts, there were some exceptions, without him going along with her. And he was considered to be in charge of their property. Even her separate property was his to manage as he saw fit. So she was like a ward of his, or like a child. Only with the enactment of the Marital Property Act in 1967 did married women gain equal contractual powers and the right to control those portions of the community property that they earned. This is a picture of a woman named Louise Raggio. She was a prominent Dallas lawyer in the 1950s, and she is given a lot of credit for writing the Marital Property Act in 1967 that basically gave married women equal rights to decide what to do with their property, to sign contracts just like their husbands could. The idea of a Texas Equal Rights Amendment was pushed for first by an organization called the Texas Federation of Business and Professional Women. And this woman, Hermine Tobolowsky, she was also a lawyer from Dallas. And around 1957, she started pushing for a Texas Equal Rights Amendment. Notice the language in it outlawed discrimination on sex, race, a lot of things. But everybody understood that this was really needed to address sex discrimination. Right? That was the real thing that was that this was necessary for at the time. So she pushed for it publicly. If it's hard to see, this is a letter that she wrote to the governor. I'll just read you a little bit of it. She's congratulating him on announcing his candidacy for re-election. This is 1959. But she says, I was deeply disappointed that you did not include in your list of unfinished business in the state the passage of an amendment to the Constitution of Texas providing that equality under the law shall not be denied because of sex. I believe this is to be the most important issue in the state of Texas. The women of Texas are not seeking special privileges, but are asking for simple justice. They're asking that they be relieved of the burden of 48 laws which discriminate against them. They're asking that the men and women of this state receive equal treatment under the law. So in 1957, 1959, for several years, every 2 years when the legislature met in odd numbered years, they campaigned for this amendment. This is a brochure from the time. Remember the Lincoln's Gettysburg Address? He said, a government of the people, by the people, for the people. So this asks, are women people? Suggesting they're second-class citizens in the government of Texas. The State Bar of Texas, that's the Association for Lawyers, opposed this amendment and argued that it would be better to go after these 48 or 44 discriminatory laws one by one and repeal them and change them than to adopt the amendment. But the advocates for the Texas Equal Rights Amendment didn't agree, and they kept fighting for this idea. This is a picture of two famous Texas politicians, Francis Sissy Farenthold on the left and Barbara Jordan on the right. They introduced in the House and the Senate the version of the Texas Equal Rights Amendment that eventually got passed. And it passed in 1971's legislative session, and voters endorsed the State Equal Rights Amendment in November of 1972, and it passed overwhelmingly. I was actually pleasantly surprised to see this. I thought it might be close in Texas at that time. The yes votes were 2,156,535. That's 79.73%. The no votes were 548,422. That's 20.27%. So the yes votes were 4 out of 5. And the no votes were 1 out of 5. A few months after it was passed, women legislatures employed the new amendment in preparing several laws to halt discriminatory practices. Successful bills included one prohibiting sex-based discrimination in loan and credit applications. And another bill disallowed husbands from abandoning and selling homesteads without their wives' consent. Before that, the husband could sell the home without the wife agreeing to it, and she could be left homeless, perhaps. So, that's it for today.